something, but if that happened, I think ultimately it would be a matter for government to decide which areas didn't warrant prosecution, and that wouldn't be a very palatable question to ask or be answered.
Still, if I were a criminal or a people smuggler, I'd be gratified to hear the evidence you've given this afternoon. But Senator Seselja.
Yeah, Chair, just following up on that. So, Mr Bryce, you've said that you haven't gotten to the point where money has been the determining factor in not prosecuting, even though money has been stripped out, and that's led to you running deficits instead of not prosecuting in those circumstances. But I'm interested in this direction. Was a rationale given for that direction, and was it a financial rationale, or was it another rationale?
I wasn't in the position at the time. First of all, I have to say that it took place in August 2012. It was 2012, and I only took up the appointment in December 2012. So I'd be going a little bit second-hand on that. My understanding was there was a degree of public controversy in relation to prosecuting crews, and there was the direction was given. I don't think it was financially driven. It was to do with principle in relation and the view of the government of the day as to whether a prosecution should take place under the mandatory minimum provisions under Section 233 capital C of the Migration Act 1958.
So how many prosecutions didn't occur? Because obviously for this direction to apply, you have to have a potential prosecution and then apply the test that you're not going to prosecute, because there's a series of matters that you need to consider whether the person fits a particular category. How many didn't occur as a result of this direction being implemented?
Where's the number? Just, if you would give me just one moment, Senator, I'll see if I can find the number. I know it was over 100 cases that were discontinued. I just wanted to get the precise figure if I could. Excuse me one moment, Senator.
But I assume, Senator Seselja, that the number would be greater than 100, because the relevant question would be how many cases were never commenced that would, in the ordinary course of events, but for Attorney General Roxon's directive, have otherwise been commenced.
Correct, and there must be some ability to gauge that number, because, as I say, a test would have to be applied where a prosecution is not launched as a result of this direction. You would have to consider this direction and consider the individual circumstances of the individual.
Well, what happened was, when the direction was given, an assessment was carried out of existing prosecutions, and those matters that could not be continued in the application of that direction were discontinued. A number were continued in relation to lesser offences, and then when it came to new matters coming through the door afterwards, they were measured against the direction.
Yes.
And from time to time, a question came up for determination as to whether an exception to the direction applied. So, for example, whether someone was a repeat offender and so on. And if an exception to the direction applied, then the prosecution would still be brought.
So how many were discontinued?
I'll have to take that on notice, Senator. Okay. It's just I do have the number here somewhere. I just can't lay my hands on it, but it was something in excess of 100.
Okay, so in excess of 100, and you'll get us that number. And
yes.
Then do you have an ability to tell us how many were not launched as a result of this direction being applied?
I'll have to take that on notice. I don't know how readily that can be ascertained, because it becomes like any other criterion deciding to prosecute, and we don't necessarily see all the matters at the higher levels where there's a decision not to prosecute any more than we see all the matters where there isn't sufficient evidence. You have certain parameters.
So this direction could then be applied at a low level, where a decision is therefore just taken, well, this person fits the exception. That's right. Given by the Attorney General, and therefore no prosecution. So that wouldn't necessarily be recorded anyway?
It's not a case of, it's a question of whether it fits within the direction. If it fits within the direction, then it wouldn't be prosecuted under the terms of the Section 233 capital C, yes, to which the direction applied, and it would only come to me, for example, if approval was being sought to prosecute despite the direction by reason of exception to the direction within its own terms applying.
It would come to you, but what I'm saying is at a lower level within the office. Who's making that decision then? If it's not coming to you,
At a case officer level, I'm not saying
Yeah.
we didn't measure it. I'm saying I'm not sure if we did or not.
sure. Is it possible to ascertain that? Is it possible to check whether that is ascertainable, whether that information exists?
If I could take that as a question on notice as to cases that weren't prosecuted but could have been but for the direction, and we'll ascertain whether we have that answer, and we may or not have it.
I'd appreciate that, and perhaps to yourself, or maybe the attorney knows the answer to this. If someone is not prosecuted who otherwise would be prosecuted under this, and there's no prosecution takes place as a result of this direction, in the ordinary course, are they simply deported? What is likely to happen to such an individual, given that they're not going to go through the criminal process in Australia?
Well, the greater impact of the direction, I'm not quite answering your question, but the greater impact of the direction was on choice of charge. It was to do with a base non-mandatory minimum offence rather than the mandatory minimum offence.
Yep.
So the greater impact was on choice of charges. But if you then, if you don't have enough evidence, and it's somebody who is not a citizen, in terms of the language of the Act, an unlawful non-citizen, then depending on whether or not they had a claim for a protection visa or not, would determine whether or not they stayed here or not, or whether they were returned.
And in that circumstance, if they were returned, under the terms of this direction, as I read it, if they were to engage in people smuggling again, they wouldn't be deemed a repeat offender, would they? Because they haven't been prosecuted.
Well, the reference refers to, in paragraph 3, the direction to a person as being convicted of an offence. So to that extent, that's to... But repeat offences, if I'm correct, they don't have to be... Just turning over to repeat offence in paragraph 7, just turning over, is defined whether someone's been convicted, the person has, without recording a conviction, it's been found they've committed an offence. So that's the...
Indeed. So
or
on
an
that,
equivalent under a prior section. So the answer to your question is yes, Senator. I'm sorry.
Thank you. So just to sort of clarify then, if they got off under this exception and weren't prosecuted as a result of this direction, and they were returned to their home country, if they came back and engaged in people smuggling again, they could potentially be subject to the same direction not to prosecute as a non-repeat offender.
That's correct.
Extraordinary. Thank you, Chair.
Any other questions?
Excuse me, Senator, I just want to make sure I've got that answer correct. That's correct as far as it goes, but I'm reminded that someone can still be prosecuted for a Section 233A, which is not the mandatory minimum, it's the base offence. So as I said, the major impact of the direction wasn't in terms of not prosecuting. The major impact of the direction was in terms of choice of charges.
Great, and without labouring the point, because I'm just getting across this direction, and I apologise for that, but member of the crew and crew member is a different term, obviously, because that determines whether or not they're the master of the vessel or just an ordinary crew member. That would be the distinction that is under this direction.
Well, the member of the crew extends to pick up the captain or master under the definition,
But that is separate from crew member, which is
That's right.
part of what the exception
That's right.
applies to.
It's designed to pick up people who are no more than crew members. That's correct.
Thank you.
Mr. Bromwich,